Hello and Namaste. I am Ketan Kang from 192 Consulting. In this video, we are going to discuss about the differences between the transfer, transmission and transposition of shares. So let us understand the concept of transfer briefly. So transfer is the exchange of the shares from one person to another in return of some consideration. Transmission is the delving of the shares from a person who is deceased to his legal heirs, and transposition is merely the changing of the name on the same shares of the multiple holders. So see, the basic principle of transfer is that it happens for consideration. Transmission, there is no consideration because one of the person is not alive. And thirdly, for transposition, it may or may not be against the consideration because both the persons may or may not be alive, and even if both the persons are alive, the change of the sequence may be due to some consideration or maybe with or without the consideration between the alive stakeholders. Transfer is by the act of two people or by the act of two persons or more than two persons. Transmission is because of operation of the law, and transposition may be either by the act of two or more persons or maybe the operation of the law. There are two cases or there are two categories which can be contemplated. First, the transposition may happen by the mutual understanding between two persons who are alive, or transposition of the name may take place as a part of transmission or name deletion. In that case, it may happen because of operation of law. So that's why I mentioned that transposition may happen because of the acts of persons or by the operation of law. As transfer happens only by the act of persons, transmission happens only by the operation of law, transposition may happen by the act of persons or by the operation of law. Now, if we take these three things or three concepts in the context of reclaiming of the shares, first, it is imperative for the investors to verify whether they have transferred the shares or not. Because initially in the physical era, the person, the transferor, used to execute transfer deed, and that transfer deed used to go to the transferee, and then the transferee used to lodge it to the company, and the company used to give effect to the transfer deed if the deed is correct in all respects. Many times it used to happen that this procedure was not getting followed. So even if the investors are under impression that they have transferred the shares, there may be chances that the shares are still into their name because the transfer procedure, the legal transfer procedure, was not duly being followed. Investors need to understand this. They might be under impression that the shares are being transferred, but still, if the shares are in their name, this misnomer, this misconcept, or this, I would say, lack of knowledge may result into investor sitting idle on huge amount of money sums. For transmission, it is very important for the investor to know about the investments their ancestors have made. So investors, see, in transmission, normally we come across two types of cases. One, the investors are not at all aware about the investments that their ancestors have made, and two, there are some old documents relating to the companies, to shares related to various companies lying in their home, but just because they are into their fathers or grandfathers or forefathers' name, the existing alive legal heirs are unaware about what to do about this. So there is the procedure wherein those investments can be made, or the names of the legal heirs can be recorded on the records of the company, and this recording of the name on the company's register is called as transmission of shares. So once this transmission of shares, the procedure for a transmission of share is completed, these legal heirs become entitled to all the corporate benefits accruing from those investments which their ancestors have made. And in transposition, as I have said, it can happen either between two existing investors, shareholders, or it may take place as a part of deletion of name or the transmission of shares. If the shareholders are reclaiming the old investments, they need to understand these concepts of transfer, transmission and transposition, undergo one or more of these procedures before reclaiming these investments which have gone to IPFA, and then only after streamlining all the documentation and correcting the records or the details of their investments on the company's end, then only they can proceed with the reclaiming of the shares. Many a times investors are ignorant about these procedures, and hence, despite following rigorous documentation, they fail to get the claim approved from the company side and eventually from the IPFA. And so that's why we have brought up this conceptual clarity video on transfer, transmission and transposition of shares. Should you have any query related to the transfer, transmission or transposition of shares or reclaiming of the shares, you may please feel free to contact us, or we will be all the more happy to help. You can contact us, you can reach out to us by marking your comment on the comment section of this video, or you can also write an email to us on info@192.in. Till the time, this is Ketan Kang signing off. Thank you so much.